The actual request. Item number 4.
Item number 4.
Item 4. Here, they have, the petition has filed an affidavit in reply. During it, I need some instruction on that, but I prefer to do this thing.
You get the records also. You have informed the petitioner.
I will come.
So-
Here it is in court.
Mr.
I have
Dina,
informed.
that senior government Assam for bidding for the school number 3 to 12 has submitted that in view of filing of an affidavit in reply on behalf of the petitioner on 10/6/2025, he needs 2 days time to obtain certain instructions in the matter. As short put, place the case on Wednesday. Wednesday?
That's no.
Take on comment on the way of 9 hours. Mic system to goal.
But I have to represent it before.
Huh?
I have to represent it before.
Dispur?
This for some records from the SP office, jail authority also, because the service and these things are there.
No. Otherwise, it will go, it's not proper also to put it before after the vacation also. Make an endeavor.
I'll
The relevant records shall also be obtained by the senior government advocate or producer of the court on the next step. So I would be submitted that council has been taken and council put a petition to make the prayer.
Wait, please, your lordship.
Hmm.
Lordship, I beg to mention for listing of 1IA in criminal appeal. Lordship, in this case, we have filed IA for suspension of order today. As such, lordship may fix a short date.
Pursue before the registry.
So we filed an habeas corpus on Saturday, so for listing.
What kind of habeas corpus?
The person is missing from 25th May.
Yes, Mr. Pang. Whether this kind of repeating habeas corpus here is listed here or before that?
Suppose your lordship, earlier matters have been listed there, another.
Okay.
But there are some cases which are listed here also. I have seen item number 2.
Okay.
This is listed, madam.
Okay, then.
Tomorrow. Much.
Item number 14. There are some development in the case, so I may be allowed to file an affidavit, agency affidavit. So make 10 days may be granted. 10 days may be granted for filing.
Okay. Mr.
R. Sharma.
R. Sharma, regarding council court of petitions has sought for, has submitted that and there are subsequent developments in the case and he needs 10 days time to bring such subsequent developments on record by way of an additional affidavit. He has thus paid for listing of the case after the ensuing summer vacation.
After 16 July.
Place the case on a date immediately after. The prayer is allowed to place the case immediately after the ensuing summer vacation.
I don't know what.
My lord, the petitioner is the secretary of Tulsi Nadi Prathamik Bhumi Suraksha Samiti. My lord, a committee fighting for the common interest in the area of my lord, Harsinga Revenue Circle in district Udalgam. My lord, for operation of some stone crusher, my lord,
Yes.
causing adverse environmental impact on the nearby agricultural fields, my lord, in Buchichang area.
Mr. Chupan, what kind of efforts you have made to obtain information whether these stone crushers are legally permitted to function or they are illegally
lord,
operating in the area?
illegally operating, my lord.
No, what kind of efforts you have made?
We submitted applications, several applications. before the
Where?
Deputy Commissioner, my lord. Page
The commissioner is not the authority perhaps.
63, my lord, page 63, kindly see.
These stone crushers, according to your document itself
Yes, ma'am.
or your information that stone crusher rules somewhere. You have annexed.
Yes,
Is it not?
page, my lord, 74.
Page 74.
Yes, ma'am. 72, 3 and 4.
It is a pollution control board. Will first allow
But my,
Forest Department, NOC, then Pollution Control Board. What efforts you have made to obtain information from them?
my lord.
At least you should have made some application under RTI to get information that they are not having the necessary license from NOC from Forest Department, consent to establish or operate from the Pollution Control Board.
My lord,
You have filed a PIL without.
my lord, kindly see, my lord, page 63. The district commissioner, my lord, we submitted an application before the district commissioner, Udalguri, my lord.
But this is stopping.
Yes, ma'am. But
Huh?
nothing has been,
No, suppose a few industries are operating in an area. You file a PIL that they are not operating with proper licenses. Is it the function of the PIL code to make a roving inquiry?
but my lord,
At least you should have made some effort to get information under the RTI from either Forest Department. Come to page 74.
let me say, my lord, I've seen it.
Then at least you should have made some endeavor to obtain information that they are illegally operating.
Some public meeting also was where my lord held, page 66, my lord, kindly see. On 7/3/25, my lord, one public meeting was also held, my lord, and petitioner
These are by you. These are by you, is it not? This is for filing a PIL.
yes, no. Resolution number 2.
What
Resolution number 2, kindly see,
investigation you have made?
page 67, my lord, relevant person.
This is permitting you to file an
Yes.
PIL.
Yes.
But what is the effort? Come to 74. 73 is the rules.
Yes.
Now come to 74. Establishment of stone crusher, Forest Department on production of NOC and consent to establish of the Pollution Control Board shall allow establishment
Yes, my lord.
of stone crushers.
My lord, kindly see page 73, restriction on setting up of stone crusher.
That is what?
Yes, my lord, kindly see, my lord, for establishment of a new stone crusher, public hearings shall be conducted in the concerned Gaon Panchayat for assessing the accessibility of the unit by local people and without no
Mr.
objection.
Chauhan,
it is
I am
not-
on
it is not
what
done.
kind of effort you have made to get information that these are illegally operating without licenses. You should have approached the proper authorities before that. At least that you have made an application to get the information that they do not have the NOC from Forest Department, they do not have the consent to establish from the Pollution Control Board, and
But they have not taken consent from my lord, Gaon Panchayat.
this is your, yes,
Gaon Panchayat.
have you got the information? This is your statement,
Verbally,
verbally. Take proper instruction. Yes, Mr. Google. Huh. Huh. That we do not know. We are not going for a fishing inquiry. We do not go for fishing inquiry. You file a petition, thereafter inquiry. No. First inquiry, then we file a petition. Why not? If make an effort to get the information, file additional affidavit, if required, then only will
Yes,
proceed.
my lord. I will file an additional affidavit.
With information that they are not having proper licenses.
Yes, regarding.
Yes, Mr. Gogoi?
No, my lord, I will additional affidavit.
Oh, it is not there. Oh. They are even not there. Pollution Control Board is also not there. Then it is defective. Non-joiner of necessary parties. Get the information definitely. If they are operating illegally, it should be stopped. We are also of the view. We are also with you. But question is, the necessary enquiry should be done. Proper parties should be on record, then only.
Additional
No point.
affidavit will do, my lord.
No point. No, this is correction. Non-joiner of necessary parties. Yes. File better particulars. Will not proceed at this stage.
Yes.
Art Mr. R. Sohan, Land Council for the petitioner.
My lord, I will withdraw, my lord, with legal.
And Mr. B. Google and Traditional Advocate General Assam for the response number 1 to 1 to 5. So Mrs. Sohan has submitted that inadvertently, some of the necessary parties are not included in this PIL petition. And some particulars are not mentioned in this PIL petition. So he has therefore submitted that the petitioner would withdraw this petition with the liberty to file a press with better particulars. So Mr. Gogul and so has no objection to the statement in view of the above submission made by Mr. Chauhan and counsel for the petitioner. There is this petition stands dismissed on withdrawal with the liberty to file with the liberty as paid for.
Yes.
Then two.
Wait, please.
Yes.
Lordship of. Instructions were sought for your lordship.
Yes. Okay. Mr. Pang, do you have any instruction? You are not made party. Home and political. Is that day you are not there? Okay, time being.
List, item 23.
May it please your lordship. Lordship, opinion repeats 18/1/2020, page 31, lordship.
Regarding listing. Huh? This is not? Huh? This is regarding 1 minute. Sure, there is a note.
Lordship,
This is regarding listing of so and so. To 23. Example. Okay. 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 This is what? Oh, foreigner tribunal.
yes, lordship.
Opinion.
Opinion.
Opinion selling.
Page 31, lordship.
PS 31.
Yes, lordship.
Oh. Maybe picked up. Huh? Will you issue notice at this stage?
Lordship, In the
No
meantime-
interim, no,
In the
no,
meantime, I may be protected, Lordship.
that, all the other bench is following. Will follow same. Ah. Prayer for interim relief will be considered after receipt of the, no, not LCR, TCR. Yes, you are right to that. Heard, Mr.
A.K. Hajam, Lordship.
A.K. Hajam. Learned counsel for the petitioner. And Mr. J. Pine, learned standing counsel, home and FT minutes. NRC. For the respond number 2, 4, 6, 7. Any state council? Mr. B. Goel and additional application. Some for the respondent number 5. District Commissioner. Posto. In this rate petition, comma, the petitioner has assailed opinion stroke order dated 18/1/2020, passed by the Foreigners Tribunal number 2, Kamrup within bracket rural PS 31 of Salem at Boko in FT case number, right?
Yes.
498 or
FT case number.
BFT.
Yes.
Okay, BFT case number 269/2018. And what is FT number?
What case will be recorded?
Or within bracket FT case number 498/2006 bracket close,
Super reference number.
whereby the learned whereby the Foreigners Tribunal has declared the petition to be a foreigner, as a foreigner of post 25/3/1971 string. Post of issue which is Mr. Pine and its cynical students has submitted that the opinion stroke order has been assailed after more than 5 years. More than 4.5 years. Post issue notice returnable in 4 weeks, as Mr. Swenson has accepted issuance of formal notice with the said respondents is dispensed with extra copies in 3 working days. The petitioner shall serve a copy of the petition along with an extra to Mr. R.K. Devchudri, Learned Deputy Solicitor General of India, for the purpose of service of notice upon the respond number 1 within 3 working days from today. Post up. The prayer for interim leave will be considered after, let the records, issue notice of, let the records of FT case number so be requisitioned from the Foreigners Tribunal so. That's the liquid, the prayer for interim leave will be considered on the returnable date. Any other interim order?
Maintainability of the petition due to the assessment.
Okay. So hang on to this one. He has also raised an issue of maintainability of the repetition due to delay in lectures. Last one, the issue of maintainability of the repetition delay and lectures will be considered at an appropriate time.
May I please, the Lordship? Also, this is a matter appeal, Lordship, prepared against the order dated 25/11/24 passed by the family, principal just family court Kachar Lordship. On the last date Lordship, we were directed to amend the cost title Lordship. As such, we did the correction Lordship in the cost title.
9-5.
At this stage, Lordship, notice may be issued Lordship.
1 minute. Eight. How many times you have changed?
Lordship twice, Lordship. Lordship
Twice?
last- Yes, Lordship. Lordship, I didn't got the information rightly, Lordship.
Huh?
I didn't got the order properly, Lordship. That's why second time we did the correction. Lordship.
First time, remove bill under section 28. 28. Then second time, second time. Twenty-eight. Okay, third time. Third time.
No,
Third time corrected.
no, second time, Lordship. Twice corrected.
So third time you were right.
Yes.
Third, Mr.
A Mena, Lordship.
A. Mina, Learning Council Court of Petition. The present appeal under section 19 of the Family Courts Act 1984 is preferred against a judgment dated 25/11/2024 passed by the learned Principal Justice Family Court Kachar at Silsor in FC within bracket civil case number 313/2020. Page 22. Post of the appellant herein as the petitioner required a petition under section 13 in bracket 1 in bracket small IA of the Hindu Marriage Act 1955 before the learned family court seeking dissolution of his marriage with the respondents by a decree of divorce posted by the judgment dated 25/11/2024. The said petition referred by the appellant petition has been dismissed. Post to issue notice returnable in courts. The petition appellant shall take steps for service of this upon the sole respondent by registered post 80 within 3 working days from today.
Deeply.
Is the case of province.
Five.
Yes.
And this did bill against the order of the Honorable Single Judge Lordship regarding the NOC of for opening the pharmacy college Lordship. The judgment Lordship,
Medical Pharmacy, Dental Science, Medical College.
courses Lordship. Okay, it's good, like, this issued Lordship.
The sale and notification. Your repetition was dismissed.
Lordship,
Two options were given.
Lordship,
One, to assail the notification.
notification,
Second option, to apply afresh.
fresh Lordship.
But you opted for the third option.
Third option, because Lordship, my application is also already pending Lordship. My inspection during the time of inspection, they could not found any, some
discrepancies are there.
Lack of infrastructure means lack of infrastructure.
But lordship.
Lack of
practical-
faculty means lack of faculty, simple.
Lordship,
Fact finding
fact finding, but exactly not lordship.
by
without-
expert body.
Without lordship, infrastructure lordship, how I can go lordship?
That is the things happening everywhere.
So,
Sometimes with infrastructure, sometimes with no infrastructure, sometimes with faculty, sometimes with no faculty.
in the.
But fact finding inquiry is,
But that inquiry lordship, only they found that during page 75 lordship, during the interaction with the faculty, it is found that the quality of some of the faculties are not satisfactory.
then we cannot sit over that finding. What is the law regarding expert bodies finding in educational matters?
Lordship,
We
on
don't
that,
know. The
on-
faculties appointed by you
Lordship,
are eligible to teach pharmacy science or what else?
lordship,
Dental, medical, we don't know.
on that count lordship, I may be allowed sometime lordship, I'll reach out the law on that point lordship. I pray lordship.
During the inspection, is found that quality of some of the faculty are not there. I've seen all lectures having people, but it is found that
Find the report,
not
my lord.
their experience,
Page
required to be eligible.
No, my lord, that is not the report. Also, we find it in page 140.
140.
Yes, the latest report on 17 stage 23. That was it's arranged in the page 140. The lordship will see the summary of the finding at page 140 directly.
142.
140. Down below. Very first point is enough to take that.
We inform me to report it. Number 3 lectures will be from its getting. 2 lectures not qualified to become lecturer to fill lecture. How many was required? As part of PCI norms? No, the principal was absent.
Actually,
Anyway.
no intimation was there on lordship from their part lordship. because
Surprise taking is the best one.
with all
Mr.
respect,
Gugoi knows
lordship,
medical college inspections.
the pharmacy course lordship.
Hmm?
It is a pharmacy course.
No, Mr. Gugoi knows about medical college inspections.
Lordship. And also lordship, on the basis of the
They should
lordship,
have asked him.
When the next page.
I have referred to page 75 lordship.
You make good these
Yes.
deficiencies,
Then we can apply again for-
make good the deficiencies, apply afresh, it's up to you. You want some more time, otherwise we are not issuing notice at this stage.
Lordship on lordship's query on that point lordship, regarding the tax findings
Take the fact finding inquiry
lordship.
In fact, my lord,
by expert body.
page 144, it has been rejected finally. There is the impure order, page 144.
140.
144.
144.
Looks not making sense. Appointment. Instruction of constituted government.
Actually,
As per PCI norms. Inadequate infrastructure,
lordship.
inadequate books. I think that inspection was done by as part of direction of the court.
Lordship, regarding
Is it not?
page 127 lordship.
Let us see the judgment, let us see the judgment.
Lordship.
Somewhat,
Page. Judgment,
page.
judgment. What I referred lordship, page 127.
No,
Earlier-
judgment, total and single judge.
Learned single judge judgment is page. Quality portion lordship, page 82. So
80,
86 lordship, paragraph 19, 20.
80, such report was put to challenge. Its report pointed out deficiency. File. Page 10. Page 8, para 8.
Lordship.
To revisit the petitioner,
Lordship.
college.
In 2019, Lordship 127.
No, para 8 of the
Sorry.
job. Para 8. Yeah, that means. During pendency of WPC number 1998 to 2020 by an order dated 9/2/2021, directed the inspection committee to revisit the petitioner college. And the petitioner was directed to place all the relevant documents. Then para 9, subsequent to the order dated 9/2/2021, an inspection was carried out. And the report was submitted by Director of Medical Education on 20/03/2023. An opinion was expressed that the petition is not entitled to any NOC. Such report is put to challenge by the petitioner. Para 10. Report, 3 grounds. Without any sanction authority, the law to inspect.
The pharmacy company will say.
117.
What will be the first is the regarding department? Department. A approval subject to admission of
Submission.
submission of consent. That is from the university and consular approval from the state. The requirement is the.
But- My response to submission, Lordship.
Mr. Muzumdar, otherwise best option for you is to make good the deficiencies, call for another phase inspection. You fill up all the gaps. Get the petition.
I pray on that line, Lordship, it may be disposed, Lordship, to.
Already the
Because-
legal judge has
But
granted liberty.
my response to submission regarding D Pharma for diploma in pharmacy course, Lordship, no NOC or whatever is required. At least D Pharma may be
If that is
considered.
so. D Pharma,
D Pharma, Lordship. Lordship.
117, let us see 117 again.
117 D Pharma course, Lordship.
Was it your case, D Pharma also?
D Pharma also, Lordship.
What is D Pharma? Diploma?
Diploma in pharmacy, Lordship. D Pharma, Bachelor of Pharmacy.
But what was the nature of challenge in the writ petition?
Nature of challenging the writ petition is regarding in two parts, Lordship, the inspection report, Lordship. They have already. I have challenged the inspection report, Lordship.
If you want to make it limited to D Pharma, we can observe.
Lordship, that observation may kindly, Lordship.
That point also. Why?
No, I can say that you make an application for inspection for compliance, whether the petitioner college has the requisite infrastructure to conduct.
There is a thing of. That law must be.
Huh.
By address, only change the policy.
Huh.
Where is the policy? Policy of the for both department and department, there will be an inspection. And you have to apply.
Oh, then you have.
Lordship, I am coming on that. It's a subsequently, Lordship, because during the pendency of that writ petition, Lordship, page 127, Lordship, 127, inspection was found, all right, everything was found in Lordship, in order, Lordship.
7 November.
And the next page, procedure for applying for nursing, pharmacy and allied health services. Both requirement, these are to be followed.
If you still insist, will issue.
And
notice.
apart from that, Lordship,
Issue notice only,
Lordship, at this stage, notice with this,
but nothing,
Lordship,
nothing.
Lordship, this pharmacy education is not within the purview of medical education as per.
Well, examine that.
And
That needs an examination.
Lordship, and.
Two
apart from-
options given to you, you are
Lordship.
still insisting for
Lordship,
for a
page,
challenge to the single judge.
Lordship,
Do that.
page 127 in two
No,
thousand.
we'll not examine further, we'll issue notice.
Lordship.
We can't even see. Mr. K. Mazumdar. Council for the appellant. Good night. And during the pendency, your everything will be in limbo. Mr. Gugu will come with sub judice submission.
But Lordship, if I'll go for fresh Lordship, there are so many things will come Lordship, because my earlier application, everything is pending.
No, you could have observed that if you are still, if you have made good the deficiencies
Lordship,
as observed in the earlier inspection report,
Lordship,
then we can ask the state to make a fresh inspection. If
Lordship,
you can make submission that all three deficiencies pointed out in the inspection report
Lordship,
have been made good
Lordship,
in the meantime,
Lordship.
then we can
So on that line, Lordship, I pray, Lordship, on that line, Lordship.
you have done it or not?
Lordship, everything is there, Lordship. If necessary, I will produce the photographs, Lordships, of that. Of that is the
No,
deficiency.
not photograph. We are not, it is the expert body
Lordship,
who will examine,
Lordship.
right?
But-
We are not experts. Huh. If deficiencies have been removed, if you are making a submission,
Lordship.
then definitely we can call.
Lordship, I may be allowed to take instruction by tomorrow, Lordship,
Tomorrow,
or Wednesday. It may be parted, Lordship.
not parted,
Because otherwise,
not parted. We have not issued notice. Edit notice been issued.
Lordship.
K. Mazumdar and Mr. for the appellant. And Mr. B. Gugui.
1 and 2.
As additional provision of some for the corresponding number 1 and 2. Those are as sought for by Mr. Mazumdar. To place the case on Wednesday, to place further and place the case on Wednesday. Place the appeal on Wednesday.
Lordship, take instruction on that.
If you are confident that everything is removed,
Lordship,
all deficiencies have been removed, we can observe that
Lordship,
as expeditiously as possible, they make an inspection and submit a fresh report.
Lordship.
Item 6.
May it please your lordship.
Yes.
My lord, in this appeal, I have sent judgment and order dated 30th of April 2025, my lord. Whereby my repetition has been dismissed, my lord.
Dismissed?
Yes, your lordship.
Your repetition is dismissed,
Yes, your lordship.
devoid of any merit. Oh, you want to
In that
put the
repetition,
date
my lord.
according to your choice from the date of so and so.
Yes, your lordship.
As who is there? For the respondents? Secretary,
My
corporation.
lord, corporation is the main respondent here, my lord.
You are not, their names are not showing.
Yes, your lordship.
Standing counsel, corporation.
My lord, madam may come on Wednesday. By the time I will serve a copy, my lord.
It's fine. Mr. M. Soikia, Council for the appellant, has submitted that a copy of the appeal memo along with an excerpt will be served upon the land standing council corporation department for the respondent number 2. And finance also,
Yes, Your Lordship.
and 5. 2, 5, and 6, and to the land standing council, finance department. In the meantime, he has called for listing of this appeal on Wednesday. Sought for by Mr. Soikal is the appeal on Wednesday. Mr. The appellant shall serve a copies of the memo of appeal along with an excerpt to the land standing council corporation department and the land standing council finance department. Finance department of that's number 4. In the meantime, please the appeal on Wednesday. The names of the land standing council corporation department and land standing council finance department be reflected in the response in the call list. Are to be reflected.
Item 7.
Very brief. My lord, this read appeal is preferred against the judgment dated page, your lordship will find at page 112. 112 is the judgment, my lord. And operative portion, it starts from page 113. Well, I am, my lord, serving as a senior engineer at Badarpur Municipal Board. My specific case was that I am entitled to the, as per the board resolution and the further communication, to entitle to my pay scale, my lord, with effect from 2014. That was my specific case. But while passing this judgment, my lord,
On that part, when the matter is called up,
yes, that part your lordship will find that page 115. When the matter was called up, my lord, on that day, my lord, when there was a, my lord, there was a communication from the Director of Municipal Administration, your lordship will find page.
no, when, today when the matter is called up, Mr. Borua,
Yes. Today, when the matter is called up, Mr. Borua, learned counsel for the petitioner, has produced a copy of the resolution adopted in the special meeting of the Badarpur Municipal Board held on 27/9/24, whereby a decision has been taken to extend the benefit of regular pay scale in case of as many as 12 fixed pay employees. These are junior to me. Accordingly, those employees are now drawing a pay scale. Although the name of the writ petitioner also find place in the list of beneficiaries, yet his case for grant of regular pay scale has been kept in abeyance due to pendency of difference.
who is that resolution?
This resolution, my lord. This was, my lord, what happened during the pendency. Subsequent
Is
development.
it annexed here?
I have a copy, my lord.
Huh?
It is in the writ petition.
Because that is part of the, that is taken out of by the judgment.
I have a copy, my lord. It was placed.
Because
As
the
my-
others have to respond on it.
On that-
Because
no, my
this
lord.
court has taken note of that
Yes.
and
and-
passed the dispose of the writ petition.
Yes. On the same day, man, when I produced the copy, on the same day court.
Right, that is why,
I have copy, man.
but that has to be responded because you need your date to be,
No, that is already my specific case, page 58, your
No, no,
lordship will see.
you need your date to be on 2014 or something like that.
Yes.
Is it not?
17.
But court, while disposing of the writ petition, has taken note of this resolution.
This resolution has been taken in 24. So far, other
No,
employees.
Mr. It is not I am not here. They have to respond, right?
Yes, yes.
In this writ appeal, because court has directed that pay scale will be granted to the petitioner on the date on which his juniors engaged as fixed pay employees by the board were granted the benefit of regular pay scale. You are agree by that?
No,
You want your date of regularization,
as per the page 58, man.
right? But court has disposed of the writ petition on the basis of this resolution.
This resolution.
So it's very clear, madam, it's a perspective. Decision
That
taken.
is what,
You will have to check on this, madam. Yes, course of action. That I
No.
want it from 2014.
No, if that, okay, that is one, but if that resolution has been taken into consideration by the learned single judge, then that must be brought on record so that the others can respond whether your repetition has merit or not, has no merit. I have not seen that.
In fact, this is also a copy, my lord, given by the chairman of the municipal board council also. Respondent 7, my lord, council.
Whatever, that should be on a record.
Yes.
Better to have it record.
The lordship may issue notice, I will bring on record with this, because this was flag mark in the court.
You get the thing on affidavit.
Yes.
Thereafter, we issue consolidated notice on both. Then they can respond. Whether your case should be treated as like the others
Yes.
or you are on a better footing.
One page I will refer, my lordship, kindly consider, page 58.
No, I have seen.
Yes,
But the learned single judge has specifically
yes, yes.
relied on that particular
Hereby, my lord,
27/9/2024.
it was referred,
What is written there?
it was retired, my lord, as per the resolution, my lord.
You
Other
make
employees-
it, you make it an additional affidavit, we'll
I'll
issue
make
notice thereafter.
I'll-
Yes, Mr. Gogol,
Fine.
then we'll consider.
Oh, your lordship.
এখন না থাকিলে আকৌ respond to decline
Or if your lordship issue notice, my lord, I will assure to bring on record.
So you bring it to will thereafter.
Because I am going to retire, my lord, by March 26. Next year, March.
You make it tomorrow. You bring the affidavit, file the affidavit tomorrow. And put it on the Thursday. All our motion days. All our motion days now.
Yes.
Thursday. Mr. B. Bolua, Learned Counsel for the Appellant, and Mr. B. Gogol, Learned Additional Advocate General for the respondent 1, 2, 3. All. Not chairman is not. 4 not there. Huh? Except 4? Okay.
1, 2, 3, 5.
5 to 8. Those stuff. Mr. Borua, Learned Counsel for the Appellant, has sought for a 1 day time or 2 days time?
2 days time. my lord,
2
he
days
said
time.
foreign
2
laws.
days time to bring the resolution adopted by the Badarpur Municipal Board on 27/9/2024 by way of an additional affidavit. He has sought 2 days time to do so. Yes, on silent. Lays the appeal on Thursday.
Obliged.
May I please, your worships. In this appeal, my lord, the learned single judge, my lord, has set aside the appointment and approval of the appellant, present appellant, my lord, as president of the school SMC, my lord.
Huh?
My lord, present appellant, my lord,
Judgment, where is the
judgment, my lord, starts from page, my lord, 111, my lord.
What is the issue?
Issue here, my lord, the present appellant, my lord, he was the president of the Aikata Higher Secondary School, my lord, School Management Committee,
District Dhubri.
District Dhubri, my lord.
Hmm.
Now, my lord, and his appointment as a president, my lord, was notified on 29/3/2022, my lord.
Page.
My lord, notification, my lord, page, my lord, 29, my lord,
Page 29.
29.
In pursuance of so-and-so government notification, letter received from so-and-so. Following person was selected as president, vice president.
Page 30, my lord, relevant. Serial number 9,
Okay.
Aikata High School,
President,
Zomiruddin.
air cutter.
president, my lord.
This was a notification dated 29/3/2022.
22, my lord.
And what is the tenure?
And tenure for 5 years, my lord.
5 years. Okay.
Thereafter, my lord,
Ah,
3 guardians, my lord, who admitted their words, my lord, in the year 2024, my lord. In the month of April 2024,
Hmm.
they had admitted their words in that school, my lord,
Hmm.
and virtually they became guardian, my lord.
hmm.
Now, they have silenced, my lord, who were born in the year 2024. They have silenced a consequence, my lord, cause of action that took place in the year 2022. So we question, my lord, with due respect, my lord, their locus, my lord,
Locus they have got in 2024.
2024. But committee, my lord, was approved in the year 2022.
Doesn't matter.
Second issue, my lord, they were not affected party also because they were not aspirant candidates for the post of president also. And my lord, admittedly, my lord, what we have not, my lord, brought on record in the affidavit in opposition in the
No, on what
petition.
ground? Writ petition was allowed.
Writ petition was allowed,
Okay,
my lord,
on what ground?
ground, my lord, a present appellant, my lord, having political career. My lord.
Judgment page 117. No, it starts from which page? 111, 111.
15, my lord. 117, paragraph 15, my lord. 14 starts, my lord.
111. You are responding number 6.
6, my lord.
Okay. Para
14.
14. Mhm. Where is the notification?
Notification, my lord, page, my lord, 19 to 26, relevant page 20. my lord.
19.
19 to 26, relevant page 20, my lord.
19. 19. This is of 2016 School Management Committee.
Page
Have
20,
a
my lord.
major role. Provision of Funding Secondary School. Okay. So criteria for selection of president of SMDC is laid down.
My lord,
Okay,
page 20, my lord, close 4, my lord, serial 4.
serial 4.
4, my lord. May I read, my lord?
Huh.
Any persons who have contested any election of panchayat level / parliament or assembly election in last 20 years should not be considered for the post of the president, vice president, even if she fulfills all other criteria as indicated above. So, my lord, I have fulfilled this one, my lord, because I have not contested in any election, my lord.
And where is the notification? 27/10/2021.
27/10/2021.
21.
Perhaps that is not annexed, my lord.
Huh?
That is not perhaps.
Because
27 to 9, 2021. Just 27, my lord.
page 27.
27.
Reconciliation. Reconstitution. Submit panel of files. Appeal. It is 27/10/2021. Where is that?
My lord,
27/10.
or 2710. That is perhaps not annexed, my lord, in the.
Because everywhere it is mentioned, para 12, para 13, para 14, para 13, 12 and 13.
That is, my lord, some modifications.
Ah,
By
some
that
modi-
modification,
Yes,
came up
let
some
us see.
modifications.
Let us see.
That is, my lord, just mentioned in the order, man, indicated in the order.
Huh?
That is perhaps not, my lord, enclosed in the writ petition as well as, my lord, in the affidavit in opposition. Only difference is that, my lord, by earlier notification, my lord, power was vested with the director and the government. And by the subsequent notification, power was vested with the deputy commissioner, district commissioner, and, my lord, guardian minister of the district. And other terms and conditions shall stand
You should.
same, my lord.
Then, 27. 90. Para? It's 90. Let us see para 12.
One needed having no political background. So it's not necessary.
Hmm.
The order is now in view. There was the same person, he had a political background. Therefore, he had to be-
Well,
That is-
admittedly, appellant my lord had a membership of my lord ruling party. A membership. And that, my lord, he had resigned that membership from the party. Admittedly, my lord, that was not brought on record in the affidavit in opposition, but I have annexed in this appeal. my lord. I had already resigned and resignation was accepted also.
You filed their affidavit.
There I filed affidavit,
Uh-huh.
but I did not annex, my lord. This one, my lord, due to communication gap, maybe, my lord, because I was not
In
engaged.
the
my lord.
writ appeal?
In the read appeal, I have annexed.
In the writ petition.
In the read petition, my lord, I have filed my affidavit in opposition, it starts from page 100.
And where is the statement in the writ petition? That you have a political career?
My lord, read petition, my lord, page starts from 38, man.
Hmm.
Page 38 to 96.
In where the para 5, active member. Page 40. Not quizzes. Elected. Para 6 and para 10 of the affidavit in opposition.
My lord, affidavit in opposition, page.
Para 6. Para 6. And para 10.
Yes, my lord. That is there, my lord.
Then para 8, never contested. And para 10. Last line.
Yes, my lord.
As aforesaid that the saying deponent, though has the political career, did not contest. So what is the interpretation regarding political career?
Yes,
Some
my lord.
reliance was placed, I think.
Yes, my lord. Page 20, my lord.
No, in a judgment.
No, that has not been, my lord, interpreted as such, my lord. Now, my lord, having membership, my lord, here has been taken as, my lord, having political career, my lord.
So there was clear admission. You have a political career.
Now, my lord, that is the question, my lord, whether having simple membership of a political party, does it amount to having, my lord, political career?
What else then?
My lord, in a democratic,
Career.
democratic country
Career.
like India, my
It
lord,
is not career.
every person more or less must get some
No, that may
affiliation.
not be. Your submission may not be.
And my lord, whether it
If
should
you
be,
aspire to be a president, that is a different matter,
my lord,
irrespective of any
My lord,
political allegiance.
whether this one, local educated reputed citizen having no political career should be read, my lord, independently, or it should be read, my lord, together with, my lord, close four. Then that becomes primary, my lord.
Which one is primary?
My lord, here, my lord, one local educated reputed citizen having no political career, this condition, whether it should be read independently or it should be read together with serial four, my lord. Last 20 years, my lord, one must not have contested.
The view taken by the single judge
That-
appears to be,
My lord,
if that view is, two views are possible, we'll go by the view of the single judge.
that point is not interpreted, my lord.
Not required.
Whether having membership amounts to, my lord, having political career. Career is a, my lord, vast.
Okay, we'll lay down. Any membership of the political party means he is aspiring to be pursuing a political
And I
career.
had
So
resigned
it is
also.
included within
My lord,
that.
I had
We'll lay down.
resigned also. Resigned also, but
No,
that,
no, your admission is in the affidavit in opposition clear.
that language,
That resignation is different thing.
perhaps, my lord, his engaged.
That game is different one.
I was not engaged in that case, my lord. Other,
Admission on record.
my lord, exactly. I agree, my lord.
I have a political career. What else is different? An affiliation to a political party, membership.
No, wrong expression.
What more?
They could have made like this, my lord, that having membership does not amount to having political career. He may,
We are not, that
he
is too
could have made
dangerous,
this
a proposition to be laid down. Active member, president. What is the statement? Paragraph 5 in the writ petition?
Yes, my lord.
7 or
Yes, 38.
paragraph in the writ petition? Active member of the South Salmara Mankasar District Committee of Bharatiya Janata Party. And presently he is an executive member of South Salmara Mankasar District Committee of Bharatiya Janata Party.
I admit, my lord. Prior to being, my lord, president or prior to having approval, my lord, I had, my lord, already.
This is not a
resigned.
public document, sir. After in the appeal which you have annexed,
I agree, my lord. That is also correct.
this can be, I'll not say much.
No, my lord, already,
I'll not say much, but your statement
yes. With due respect, my lord, I
on
already,
affidavit
my lord.
is clear.
My lord, that is there, my lord.
At that point of time, there was no statement as regards submission or resignation, etc.
Yes, my
A
lord.
story has surfaced later on. Is it not? Is it not a public document? Public document. This resignation cannot be.
That was,
If you
system
can-
is there in the
You
party.
can,
my
you
lord.
can
One can join.
disprove that.
One can join, again, one can resign
You don't
also.
find any infirmity in the decision taken by the legislators. We close this.
My lord, that point only, I pray for scrutiny of that point.
We have scrutinized. We'll do it.
Having membership, my lord, if it amounts to having political career, my lord.
We go by that statement in the writ petition, which has not been specifically denied.
And that point, my lord, the guardians, my
So
lord,
it is a political career.
who became guardians, my lord, in the year 2024, and they
True
have.
career cannot be pursued. If you are an executive member of the district committee of the BJP,
I admit that. It was
You
there.
admit, then you admit that that is a political career.
It is also fact I had resigned, but that was not brought on record. madam.
But we go by the statement on affidavits. Later on these documents, I'll not make any comment. If I make any comment, it will be to your detriment. Which are your documents subsequently and
Subsequent
next in the writ appeal?
page, my lord, 120, 119 also. English version.
What took you so long to bring this 2021 letter on record after 4 years and 2023 letter after 3 years, 2 years? It took you so long. It was accepted, seal and signature, no date by the president. It was accepted, no date by the president.
Date is not there.
No
Date
date by the president.
on the top, date is there.
Okay, that is a different method. Third, AF, NU, Mullah, Learned Counsel for the appellant, and Mr. R. Ozumgar, Standing Counsel, Department of School Education. For the response number 124. Post on. Learned Counsel for the purpose of engineer writ appeal are heard on the legal issues sought to be raised in terms of the notification dated 24/6/2016. First of the writ petition. Sorry, this intra-court appeal is preferred against an order dated 5/5/2025 passed by the single judge in a writ petition, WPC number 3383/2020. So in the writ petition, the appointment of the appellant, who was implemented as party respondent number 6 in the writ petition, as the president of
Aikata ACS school.
Aikata High School District,
Now ACS school, madam.
Aikata High School,
Higher, now updated, madam.
Aikata High School, within bracket, presently Aikata Higher Secondary School, District Dhubri, by a notification dated 29/3/2022, issued no, full stop. Para. The A writ petition was preferred. By three petitioners whose words has been particular, whose words are pursuing education in Airkata High School, which is now upgraded to higher secondary school. Post of the specific ground the primary ground of challenge to the petition appellants respond number 6's appointment as the president is that the appellant respond number 6 is an active member at that time, was an active member of South Salmara Mankasar District Committee of the political party, Bharatiya Janata Party BJP, and at the relevant time, he has been serving as an executive member of South Salmara Mankasar District Committee, Bharatiya Janata Party. In view of holding such position in a political party, it is contended that the appellant respondent number 6 is having a political career, and as such, he cannot be permitted to continue as the president of the School Management and Development Committee of Airkata School for Sport আগতে কৰি দিব আৰু। Para. And reliance has been placed in a notification dated 24/6/2016 of the government of Assam in the education in bracket secondary bracket close department. Para. The school management and development committees within bracket SMDCs have been delegated a number of responsibilities like selection of principal, stroke headmaster, stroke teachers, or financial management, etc. In addition to, and they look after they play a major role in the improvement of quality of in the schools. So by the notification dated 24/6/2016, the government in the education within bracket secondary department, taking note of the fact that earlier notifications did not lay down any criteria for selection of the president stroke vice president of the SMDCs, including uniform qualification, etc., decided to lay down the criteria for selection of the president stroke vice president of the SMBC's post of para. It is set forth in a notification that any person who has contested an election of panchayat stroke parliament or assembly in the last 20 years should not be considered for the post of president stroke vice president, even if he stroke she fulfills all criteria, all other criteria indicated therein. Post of. By the state notification, state government decided to dissolve all SMDCs of the institutions mentioned therein and to constitute new SMDCs with the following composition, with the composition mentioned therein. Post of. You have graduation?
Graduation.
For the post of president and vice president in the assemblies, the person has to be a locally has to be a local resident and he should have the qualification of not less than graduation in any discipline. To stop that apart, the person has to be a reputed citizen, but without any kind of political career. Stop. In the writ petition was contested by the appellant, respondent number 6, by filing an affidavit in opposition. Stop. In the said affidavit in opposition, the appellant respondent number 6 with regard to the specific contention raised on behalf of the petitioners that he is an active functionary as an executive member of South Salmara Mankasar District Committee of the political party. The appellant respondent number 6 had admitted the said fact. In paragraph numbers 6, 8, and 10 of the said affidavit in opposition. It has been averred therein that it has been averred by the appellant respondent number 6 that he had never contested any election to attract the disqualification criteria laid down in clause 4 of the notification dated 24/6/2016. At the same time, the appellant, respondent number 6, had admitted to the fact that he had a political career. Mr. Mullah, Learned Counsel, appearing for the appellant rest number 6, as submitted in view of such facts, the disqualification clause set forth in the notification dated 4/24/6/2016 is not attracted in the case of the appellant respondent number 6. The said contention has been vehemently opposed by the Learned Standing Council, School Education Department. The Learned Single Judge considered the above aspects in order, in the impugn order dated 5/5. Two 2025. And has observed upon perusal of the records that the appellant respondent number 6 is a member of Dakshin Halmara Mankasar District Committee, Bharatiya Janata Party, as well as an executive member of Bharatiya Janata Party. Post up. In view of holding such position, the appellant respondent number 6 has clearly incurred the disqualification laid down in the notification dated 24/6/2016. And his appointment as the president of the SMDC of Air Kata School is in violation of the eligibility criteria provided in the notification dated 24/6/2016. Post on. In the notification dated the government in the education secondary department has ordered to enforce the following criteria to become a president stroke vice president of the SMDC is 21 to 3 4. On the basis of the above criteria, the state government in the education department decided to constitute new SMDCs with the composition that the president and the vice president of the SMDC should not have any political career. So, on a reading of the notification dated 24/6/2016, we are of the considered view that and a membership of a political party, a member holding executive position in a political party, recognized political party, comes within the embrace of political career as such an executive, such a member holding an executive position actively involved in the decision-making process of the political party. Post of para in an intercourt appeal, comma, the scope of interference is limited, and if the view of the learned single judge is found to be in accordance with the issue, is found to so and so, no interference is required. First, in view of the admission of the fact that the appellant respondent number 6 was an executive member of the district committee of a recognized political party, it cannot be said that he had no political career at the time of consideration of the issue of eligibility or otherwise for holding the post of president of the SMBC of the Araketa School. Post in view of the above, we find no merit in this impact of the bit for interference. Post the appeal is found to be devoid of merits and is accordingly dismissed. Post of in view of the decision. In view of the finding reached a hope, comma, discourse. The issuance of notices to the other respondents stand dispensed with. D.K. Sharma, additional senior government advocate for the respondent number.
Well, the resignation part, well, I have annexed the resignation part, but that stated, my lord.
Which one?
Resignation.
Which resignation?
That, my lord, I had resigned much before I was, my lord, approved as president.
Make comment. We'll make comment. Okay, we'll make comment.
Only thing.
After admission in the read petition, these are documents of 2021 and 2023. We are moving to make a very adverse comment.
No. No, I would do.
Otherwise, I thought it over, but your political career will be hampered. I thought that better you pursue the political career.
So, my lord, the issue of maintainability was also kept open by the
Which one?
single judge. That, my lord, guardian who became guardian in the year 2024, they challenged that issue was raised, my lord, and the issue of maintainability was kept open also, but that
Which
was
one?
not discussed. Page 98.
On locus.
On locus.
As soon as they became guardians of the school, they had the locus. Will observe.
Page 98.
Page 98.
99.
Have you denied that they are not guardians? of works who are pursuing the education in the school.
No, they become, that is not disputed.
Huh. Then you want finding on locus?
But as the learner singles us, my.
Okay,
it's a
para,
past
para,
order.
para, para, para. Para. Which page?
Page my lord, 99 relevant,
99.
last two sentences.
99. Sir, that was an interim observation.
Interim observation. But that I have placed my lord.
That has
was
attained
not-
finality by the judgment.
That was not discussed.
That is not the ratio.
The ratio. is not. Obliged. my lord.
Item number 9.
Wait, wait, wait. No, in this case, is the quantum of the compensation which was awarded to the petitioner, Manoj, who is the appellant hearing. That, Manoj, is under challenge. But all the findings of the learned single judge are in my favor. The only issue is to be regarding the quantum. And the quantum, Manoj, was arrived at without any discussion as to what would be an appropriate compensation. But Lordship will have, the
Public raw remedy compensation, that is a discretion of the last single judge.
discretion, yes, Manoj.
It is absolute discretion.
Discretion is there. Manoj. But
Because I think, whatever, even given the liberty to pursue civil remedy or not,
a civil remedy, yes. That is there.
then
Well, the issue is that, Manoj, in the writ petition, the petitioner filed the documents and made specific pleadings that he has incurred nearly 7.5 lakh rupees only on the medical expenses. And that too was only till 2018. And Manoj, till 2000, and this has not been disputed by the state as such. And the learned single judge has also found, Manoj, that the authorities did not disburse or pay any amount to the petitioner at all. In fact, the entire stand of the state, Manoj, from the beginning, the date of the incident till 2024, was that the matter is under investigation and the petitioner may also be involved in the violence that has taken place. But the fact remains that, Manoj, when the charge sheet was filed, Manoj, we do not know where it was filed because, Manoj, it was only disclosed orally, no document was filed. Now the state came up with the stand at the end stage that the petitioner has actually been cited as one of the witnesses. And in fact, he was injured by due to the
no,
negligence.
Mr. Ganguly, this is a public raw remedy.
Lordship.
But basic issue is whether his fundamental right has been violated or
Yes,
not.
and that has been found by the
Uh-huh.
learned single.
And thereafter decided to pass an order on compensation.
Lordship.
That was in absolute discretion of the learned single judge.
Discussion, yes, Manoj, but at least, Manoj, the part.
Taken
because-
into consideration, age of the petitioner, his income or earning mentioned in the so have been duly considered.
Well, but that discussion, Manoj, is nowhere, and Manoj, the medical treatment part, well, in my rejoinder, I have placed documents and made a specific.
Because but to show me any public wrong remedy, the medical, because the remedy is available to
Lordship.
you
Lordship,
that you have to pursue,
I have to. pursue.
right?
Lordship.
Exactly what kind of disability you have occurred
Lordship.
and treatment.
But
Whether, show me anything that in public law remedy while granting compensation
Lordship.
under Article 226,
Lordship.
these factors are required to be considered.
Well, the issue herein is, I only, the submission, that, Manoj, I have, as I said, Manoj, said that this was my medical expenses and the medical expenses till 2018. And I am a permanently disabled
These
person.
are evidence to be proved.
True, but this is not.
This is not,
Not disputed by the statement, not disputed. It remains unrebutted, and the learned single judge has also not held that these medical documents are, Manoj, in the.
he is not in a position to do so
That may be, but the fact remains that,
because
Manoj,
these are to be, these are evidence.
otherwise these are evidence, Manoj. But had the state will not come up with a dispute that no, we dispute these medical evidence, or Manoj, if the learned single judge has found that these medical documents and this part is Manoj needs adjudication.
Any decision that even medical evidence or medical treatment part is also to be
Let's keep.
taken into
ultimate-
consideration while granting the
Fair. Well, look, in a case where there is a dispute between both the sides, yes, lordships would remand us to the civil court, have the liberty there to read the evidence. Where there is, my lord, there is no such dispute.
because he has not entered into that
No, he is not.
exercise.
He is not. But the figure of
Because
5
he
lakh-
was not required to do so.
Perhaps not, my lord, but my lord, in a case where there is, my lord, no dispute and where the stand of the state, my lord, was only.
Serious reasons. Yes, Mr. Sharma.
Well,
The full discretion exercised by the single judge.
secondly, my lord, in any scheme of the compensation scheme available in the state, the highest compensation rate is advance. Not more than that, my lord. I have handled some other cases also, where my lord, the division bench, my lord, directed to fix the compensation amount. That was my lord, raised before the Supreme Court, and how to accept it. Police proceeding case also. my lord.
That scheme has not been considered by the Learned Civil Judge.
That issue has not come up before him.
No, it is not, because that.
An issue which has not come up before him,
No.
how he can consider?
No, my lord, the notification was relied upon by the state, my lord, before the.
Where?
Learned Civil. It was placed, it was handed over, it was not filed with the affidavit. It was handed over to the Learned Single Judge. And Learned Single Judge said that perhaps the report would not be
Yeah,
bound.
An issue notice, but
Notice.
eternity of the appeal will be considered.
Lordship.
I'm not very sure. Public law remedy, compensation, that also quantum, on quantum retail appellate court can. If that view is a reasonable view, then what?
Yes,
else?
whether that is a.
Liberty was granted to you.
The liberty is there. my lord.
Ah.
Of course, liberty is there.
So you want to.
Well, it's civil law remedy is there. But my
Then
lord, the
all these
petitioner-
issues, damages, you can claim compensation and treatment
whether my lord,
expenditure occurred.
whether the state disputed the documents and the pleadings, my lord, to that effect. That is the limited question, my lord, because the civil law, my lords, may take a long, and already he has suffered for 8 years. my lord.
These documents are to be proved.
Yes. But they have to be disputed also. my lord, by the
We
others.
can.
Let the question of maintainability.
Read court can only draw inference that yes, he has undergone treatment for the
Yes.
injury sustained.
That has been found.
That is only there. And
Yes.
going into this total bill amount, net bill amount, all this uncertainty.
Lordship may issue notice, keep the question open.
Third, Ganguly, Learned Council for the Appellate and Mr. D.K. Sharma, Learned Edition, Senior Government Advocate, Assam, for that's point number 125. Why 5689
Look, they were even the parties in the writ petition also, and
for the treatment cost?
for the for the cost, but to prove the factum that he had taken treatment at that basis. And the my lords, respondent number 8 was the army
Mr.
hospital.
Ganguly, you are expanding the jurisdiction too much.
Well, they were parties in the writ petition, so I have
Jurisdiction.
taken parties here. They were not parties in the writ petition. If I do not make them parties in the appeal, then they will take the objection. Well, it's a formal defect.
Yes, who, Ms. Sharma, you represent?
As for 8, well, I think the
Yes, sir.
CGC will perhaps appeal for the.
Is a party?
As well, as respondent number 8 is the army hospital. Mr. S.S. Roy was the counsel in the writ petition.
Okay. Yes, Sharma and Standing also health and family welfare department. For the respondent number 6, 7, and 9. Mr. Roy is available. The appellant writ petition being agreed by the quantum of compensation granted by the learned single judge. In exercise of public law jurisdiction. Quantifying the amount at rupees 5 lakh. Being dissatisfied and aggrieved. As before. This recap. The Land Council for official response. Have raised an objection as regards maintainability of the RTP. Issued just returnable instructions. As when to appear, accepted notice. Issued of formal notice to the said respondent is dispensed with. The Land Council for the appellate petition shall serve a copy of the memo of appeal and with an access to the understanding Assembly Government Council for service upon the respondent above. Eight. Within 3 working days from application. The issue of paternity of the appeal is left for consideration, is kept open for consideration at an appropriate instance.
Number 10.
May it please, your lordship. My lord, in this matter, a notice inviting tender was issued by the Food Corporation of India, wherein, my lord, the Food Corporation of India invited various bulk bidders, various bulk buyers, manufacturers of the wheat to participate in the e-auction for procurement of 100 metric ton of wheat, my lord. My lord, all the appellants in this matter have participated in the tender, and subsequently, my lord, a letter of acceptance, from acceptance offer was issued by the Food Corporation of India. And subsequently, my lord, a rejection email was issued by the Food Corporation of India, wherein the reason for rejection was that the bidders having GST registration based out of the state of Assam cannot participate in the tender process, my lord. Reason which, my lord, the present writ petition was preferred by the all the appellants, my lord, in this present petition, my lord. My lord, in this matter, before issuance of the acceptance offer, my lord, there was no opportunity of being heard was provided to the appellants, my lord, in any of the case. And without issuance of any kind of a show cause notice or giving an opportunity of being heard.
In tender matter not required.
My lord,
Jagdish Mandal is referred.
my lord, it is.
If Jagdish Mandal is referred.
It has
then
been referred,
principle
my
of equity and natural distance,
Yes, my lord.
natural justice,
Yes, my lord.
stay at a distance,
Definitely.
right?
Yes, my lord.
It is quoted already,
Yes.
paragraph 21. That stay at a distance
Yes.
in a tender matter. Come to your paragraph 22 to 24.
My lord. My lord, in regard to paragraph number 22 and 22 to 24, my lord, the question in regard to the cause of action has been kept open by the learned single bench, my lord, in this matter. And my lord, the learned single bench has raised an issue that the addresses of all the petitioners, that is the appellant, is same, my lord. My lord, that may not be the bar for the petition to be not maintainable, ma'am.
We'll go with the High Court rules. After finding merit, he made this observation.
No.
Show me your writ petition was maintainable with 1 court fee. Show me.
My lord, all the petitioners have been working together and.
That cannot be.
And they
That
have-
cannot be in a
my-
tender matter.
My lord, they have a.
Competing parties may have a address, though we are not going into that. Filing a writ petition with one court fee. Show me from the High Court rules
My lord, the
that
cause of action-
it is permitted or not permitted.
My lord, the cause of action is similar, my lord.
Cause of action similar, but everybody has to pursue it differently.
My lord, definitely the cause of action is similar. The
Cannot.
issue is totally
Cause
identical.
of action is different, but everybody's interest is different.
My lord, the
No, every petitioner have participated independently, my lord. Every petitioner have participated
Everybody has
independently.
participated by submitting different tenders,
Yes,
My
sir.
lord,
right?
my lord.
Own independent tenders. Now show me the provision as regards court fee.
Apology, my lord, I do not have the Guwahati rules as of now with me, my
Mhm.
lord. My lord, all I'm praying is, my lord, notice may be issued.
We'll make the endeavor for you.
My lord, all I'm praying is a notice may be issued.
No
at this stage,
notice
my lord.
if we don't get ourselves satisfied.
My lord.
Yes, show me, Mr. Respondent, brief petition. So, just. And when the tender was issued,
My lord, the tender was issued on 7th July 2023.
then judgment and order,
In regard
September
to the
2000.
rejection email, my lord,
18/9/2024.
judgment.
Impugned judgment.
Yes, my lord.
And today we are in June,
My lord.
after 9 months.
My lord.
9 months.
And what is the tender actually?
My lord, the
What is the
tender,
tender for NIT?
it is for procurement of 100 metric ton of wheat, my lord.
Where is that NIT?
My lord, NIT is at page number 148, my lord. If your lordship may look upon page number 156, my lord, of the NIT.
Yes, Mr. Singh.
My
This
lord, their
auction had
main
occurred
prayer
or
was
not
for the
occurred?
release of the EMD.
Huh?
My lord,
This
their main
auction,
prayer is basically for release of the EMD, my lord, which we have forfeited.
Herein, my lord, we have submitted the EMD amount which was forfeited by the Food Corporation of India, and thus our claims only pertains to the EMD amount, my lord.
then how can it be retailed then?
My lord, we preferred the writ petition. We were just
What was the prayer in the writ petition?
if lordship for the refund of the EMD amount, my lord.
Where is that? What was the prayer?
At page number 129, my lord, the prayer portion of the writ petition is there.
129.
My lord, herein it is stated that at prayer 2, my lord, why a writ in nature of mandamus shall not be issued, setting aside and quashing of the impugned email, the email in accordance to which my EMD was forfeited, my lord. That email I have challenged in the writ petition, my lord. Dated 20 July 2023. Thereby the tender
Stated in an email.
until the pendency of the writ petition, my lord, there was no official order for the forfeiture. We were orally and verbally informed.
Where is that email?
My lord, the email is at page number 130. 140, my lord. Dejection email. Herein it is stated, my lord, as per the terms and condition envisaged in the MTF and further clarification received from the FCI headquarters, it is to inform that the parties bidders having GST registration other than Assam region cannot participate in the e-auction of wheat under OMSS D, my lord. Mainly because
Then where is the tender again?
NIT, my lord, NIT is at page number 148. The Lordship may look upon page number 151, my lord, of the NIT, which is stating the technical qualification of empanelment of the bulk buyers, my lord, in regard to eligibility and qualification.
Mr. Singh, whether this auction has occurred or not, come to the.
Well, auction has occurred and we have given the appointed the contractor also, my lord, pursuant to NIT, my lord.
Then what remains?
My lord, my EMD.
So far, page
Only
148.
EMD, my lord.
My lord.
Please
They
read
want
first
EMD.
para. Please come to the main issue thereafter subsidiary issue.
My lord, my lord. At page 148.
Yes. Read.
The Food Corporation of India, my lord, the first page of the NIT.
Yes.
The Food Corporation of India, Regional Office Assam, Guwahati, invites bids from flour mills, traders, empaneled bulk buyers, manufacturers of the wheat products for the sale of FAQ URS wheat of various crop year under open market sale scheme, lying at the various depot through e-auction. Following are the details of the tender inquiry dated.
So if e-auction has occurred,
my lord,
everything has been lifted.
My lord.
So far as this is concerned, the main issue regarding e-auction, that has become infectious. Parties have been appointed.
My lord,
That
I'm
has
not
written.
changing the tender, my lord.
So let us be sure about it, right? What will be the contours of the writ appeal, right? For consideration. So first thing is that this e-auction has already been held, and this was an NIT of 7/7/2023, 2 years back.
Yes, my lord.
E-auction has occurred,
Release
right?
has also been given to all
Right.
the bidders. Successful
And
bidders.
all the successful bidders
Has been given release order. They have lifted.
have been
my
selected
lord.
and they have lifted whatever is there,
My lord.
bulk quantity.
My lord.
Is it not?
Yes, my lord. They have lifted all the
So the subsidiary issue is that your
EMD.
bids
EMD.
were rejected, right?
My lord, my bids were accepted. In fact, I was declared as a successful tenderer. That's why, my lord, the principle of natural justice angle is coming, my lord. Had it been the case, my lord, that I have not been issued a acceptance offer, I was not declared as a successful tenderer. The principle of natural justice.
Where is the
has not-
successful tenderer?
My lord, I have been issued a letter of acceptance. If your lordship may look upon at page number, my lord. (166), my lord. Herein, my lord, I have been issued a letter of acceptance, which amounts to a binding and a concluded contract, my lord. And your 166, my lord.
That does not always result in binding contract.
Lordship, at clause 9 of the NIT, it is stating that issuance of acceptance offer amounts to a binding contract.
Acceptance offer under so and so. Food Corporation of India. You mean to say this acceptance letters were issued?
Yes, my lord. And after that, my lord, it has been terminated by simply issuing an email, not even a rejection order, my lord. And that too by an authority who is not empowered to issue a rejection email, my lord. My lord, there are various grounds in this petition, my lord. If your lordship may look upon clause 9 of the NIT, my lord, which is stating it would amount to binding contract. Page 156. My lord, clause 9 pertains to communication of acceptance. The contract, if any, which may be eventuate from the e-auction shall be governed by the condition as mentioned in the terms and conditions of the e-auction. Its appendices and annexures, notices inviting and acceptance letter, so and so forth. My lord, the last paragraph, emphasis applied. The acceptance of the bid by the general manager or an officer authorized by him or on his behalf shall constitute the contract between the bidder and the Food Corporation of India, and no separate agreement is required to be executed after the issuance of the acceptance letter. My lord.
Yes, Mr. Singh, so far as EMD is concerned, this issue is
Yes,
only
ma'am.
limited to EMD.
Yes, my lord.
Is only limited to EMD, my lord.
Yes.
Though, my lord, I have also prayed for compensation for loss of profit, but if your lordship may consider it at a later
No,
stage,
we'll-
only my
we'll-
primary submission is in regard to EMD.
We'll make it limited only to refund of EMD.
My lord, my lord.
Yes, my lord.
Because
Yes,
you
my
are
lord.
not interested, because it seems that the judgment and order was delivered on 18/9/2024,
My lord.
right?
Yes, my lord.
And we are in June
My lord.
2025.
9 months as well.
9 months have
There were
elapsed.
certain
Whatever,
discrepancies with the-
whatever, you are not pursuing the main tender. That has already been walked out.
My lord.
Compensation part, you go in a different forum. But regarding refund of NIT, we can only consider that issue. Because once acceptance letters has been issued to you, thereafter it has been changed.
My lord.
So you may have a case there regarding refund of
Yes,
the EMD
EMD.
at rupees 1,10,000.
1,10,000.
Yes, we can issue on the Mr. Singh.
Yes,
Because
my
there
lord.
are acceptance letters.
Yes, my lord. I will satisfy on the returnable deed, my lord.
My lord, if your lordship may just grant me 2 minutes to persuade your lordship in regard to my claim for loss of profit, my lord. My lord.
Loss of profit, no,
My
we are
lord,
not
if your
here.
lordship
We are
may
not here. We are
grant
not
me 2
here.
minutes time, my lord.
We
I'll-
are not
I'll pursue
here.
it, definitely be able to persuade
Then,
your lordship.
no, I straightway reject that.
Then, my lord, EMD amount may be
Only
considered.
EMD
My lord.
amount, refund of the EMD amount.
My lord.
Heart, Mr.
D. Rathi.
D.
Rathi.
Rakhi.
RATHI. Rathi.
Rathi. Learned Counsel for the appellants. And Mr. Singh, you appear for?
For FCI respondent only, my lord, from respondent number 4.
Appellants. Mr. Jain, you appear for 5, 5, 6, and 7. Okay. Mr. B. Singh, Standing Counsel.
Yes, my lord. Yes, my lord.
Food Corporation of India for the respondent number 1 to 4, and Mr. K. Jain, Learned Counsel representing Mr. S.C. Kyle, Standing Counsel GST for the respondent number 5, 6, and 7. Para. Agreed by and dissatisfied with it. Judgment and order dated 18/9/2024. Passed by the learned single judge. In edit petition. Command WBC number 4749/2022. Referred by these appellants as lead petitioners. Commander instructs intercourt appeal is preferred. Postal. The notice, a notice inviting tender was issued on 7/7/2023 by the respondent FCI. Inviting bids from page 148. Flour mills, stock traders, stock empanel, bulk buyers, stock manufacturers of wheat products for sale of FAQ, URS, wheat of various crop year under open market sale scheme, domestic so and so lying at its various depots through e-auction. In response to the said NIT, the petitioners, the appellants, the petitioners had submitted their bids. Post of para. It is contended that initially, acceptance letters were issued to the appellants with petitioners on
Acceptance.
for
My lord, going to option.
for allowing them to participate in the auction, which was scheduled to be held on 12/7/2023. But subsequently come out by an email dated submitted so and so by submitting earnest money deposit EMD at rupees 1,10,000 each. Email date
My lord, the email rejection email
20/07/2023, the appellants, petitioners were informed that their bids were cancelled as they did not have the GST registration. They had GST registration outside the state of Assam, and therefore they could not participate in the e-auction of wheat. Full stop. Aggrieved by the email, the appellants petitioners had preferred the repetition WPC number so and so. And by the judgment and order dated 18/9/2024, the petition was dismissed on a number of counts. Mr. Singh, Learned Standing Counsel, FCI, has submitted that in the meantime, the auction for which, as mentioned in the NIT, has been completed.
Complete. Complete, my lord.
Is complete. Mr. Atil and Counsel. For the appellant's petition has submitted that the issue in this intra-court appeal is limited to the appellant's petitioner's claim for refund of the EMD deposited by the appellant's petitioners. He has submitted that initially, the bids of the appellant's petitioners were accepted. Issue notice returnable and 4 weeks as so and so has appeared accepted notice. Formal notice dispensed with extra copy requisite number of memo of appeal shall be served of the consequent. Is the case of the 4 weeks.
much obliged, my lord.
Right, my.
Number 11.
Heard Mr. NNB Choudhury, Learned Counsel for the accused appellant. I think that's a delay. And Miss S. H. Vora, Learned Admission Public Prosecutor for the respond number 1 state.
Yes,
One state. 2 is there?
Information is there, my lord.
Huh.
Huh?
The instant criminal appeal under section 4152B NSS is directed against a judgment and order dated 22/7/2024 passed by the Court of Learned Additional Session Judge cum Special Judge Pokso Morigaon in Pokso case number 7 of 2021. By the judgment and order dated 22/7/2024, the accused appellant has been convicted for the offense under section 6, protection of children from sexual offences in 2012. And he has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 10,000, in default of payment of fine, to undergo rigorous imprisonment for 3 months. We have gone through the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The case records of so and so case number we call for issue notice returnable in 4 weeks as Ms. Vora, Learned Additional Public Prosecutor for the clear and accepted notice on behalf of respondent number 1 state of Assam issuance of formal notice to the respondent number one is dispensed with. Extra copy of memo of appeal within 3 working days. Accused appellant shall take steps for service of notice on the respondent number two as informed in terms of the practice directions ensured. The learned additional public prosecutor is to obtain a report as regards service of notice upon the respondent number two from the officer in charge, Moringa Police Station on or before the next date of list.
Item 12. We do not approve.
May I please, your lordship? Lord, no affidavit has yet been filed, my lord.
Mazumdar,
My lord. In fact, my lord, results are going to be declared today, my lord. My lord, virus of a rule is under challenge, my lord. What they have done, my lord, mathematics has been made, mathematics honors has been made mandatory by amending the original rule, my lord. Those person who having the, my lord, honors as a mathematics, they can apply for the post of, my lord, in the mathematics subject. And the pass course, those person who are having the mathematics as a pass course, they have been debarred, my lord.
yes, Mr. Mazumdar, you are supposed to file affidavit.
Magar. Results today it is going to be declared, my lord. Wait, what is? My lord, admit, my lord, apparently, my lord, the classification which they have made by, my lord, by the,
This is a rule, what kind of rule?
my lord, the rule is a 309. My lord may be pleased to find.
309,
My
that
lord.
is constitutional rules.
My lord, that
In
is correct.
character, presumption of constitutionality is there,
My lord,
unless it is held so.
held to be arbitrary, my lord, and I know, my lord,
We
this.
can issue notice at this stage.
My lord, notice is already been issued, my lord. It is come up,
Is it?
my lord.
Notice is there. You can post it, you file your reply. Yes, by what time? Tell me the date, so when it can be.
17th.
Fix a date.
17th, my lord.
Huh? 24. You file your appeal 25th. Okay, heard Mr. A.R.V. and counsel for the petitioners and Mr. R. Mosenberg and standing counsel. Education Department for all the respondents.
My lord.
Okay. For both the respondents. Mr. Mosenberg and standing counsel Education Department has paid for. Dignitary. And is granted 4 weeks time to file. To obtain an necessary instruction and to file and the counter affidavit on behalf of the respondents. To release the case on 25/7.
My lord, may I pray for an observation from my lord? My lord, if any appointment is made, may be
It is always there.
can be subject.
It is always there. If your repetition is alive, everything is gone.
Well, obligement.
13. Item 13. May it please, your lordship. Lord, we have challenged the amendment, my lord. The lordship would kindly come to page 99. Now, this second proviso was substituted, my lord, by this amendment of 21st of February 25. Provided further that in case of amalgamated high school or higher secondary school where Middle English or Middle Vernacular school has been amalgamated, the assistant headmaster or ex officio vice principal, as the case may be, and science graduate teacher shall be eligible for selection to the post of the headmaster, subject to the condition that incumbents should have a teaching experience as graduate teacher for a continuous period of at least 15 years, including period of service in the arts while. So, my lord, once there is an amalgamation, then my lord, the assistant headmaster and the science graduate teacher alone would be eligible. We are, my lord, arts teachers. Why we have been left out, my lord? That is our case, number one. Secondly, my lord, otherwise, my lord, the high school teachers, for them the experience is 10 years. If your lordship would kindly take this.
Right. With whom you are trying to,
No, we want to be take part in the selection process, and we should be eligible. On what basis, my lord, you make a discrimination between science and arts? Now, if your lordship should kindly come to rule 14 of this.
Mr. Chaudhary, from your synopsis, it looks like you can wait.
Huh?
Because.
No.
Huh?
No, subsequently.
Because you have completed 10 years of service.
Now, my lord, subsequently advertisement has been issued. Page 97. Now,
Because otherwise also, if you,
it's a question of rules, my lord, that is there.
if we equate also
Hmm.
that graduate teacher arts and graduate teacher science are to be
Treated at par.
but you have only 10 years experience today, as on today.
But it's also
Synopsis,
15 minutes.
synopsis,
Yes,
you have said, so you have not attained 15 years.
yes.
You know, yours, I have not looked into it.
Correct. No, my lord, now the issue is high school teachers, they require 10 years. That's why please have the rules, my lord, for a moment. Of this book, my lord, page 36. You are setting a different criteria, my lord, for different teachers.
These 10 years were already there.
Yes. That's why we are referred losses.
Now, by this
on top, my lord,
by
at
this
page-
amendment,
Yes.
these science teachers have been brought within the purview.
Yes.
You have been left out.
We have been left out, and my lord, now the high school teachers are there of the before amalgamation. Eligibility for the post of headmaster, superintendent in high school, high madrasa, as the
Yes,
case may be
PH.
self-follow. He must be a BA, BSc, BCom with BT, BEd degree from any recognized university in respect of etc. Please come to B, Miller. He must have at least 10 years of teaching experience as graduate teacher, provided that graduate teacher shall include the cadre of assistant teacher. So in terms of B, Miller, as far as the high school teachers are concerned, for them, the qualifying service is 10 years.
That are in place since 2018.
Yes.
And by this
25.
notification, 2025,
Yes.
science graduate teachers from amalgamated schools
Have been made
have been
eligible,
eligible.
and however, there is a further rider that they should have 15 years experience.
15 years.
My lord, we are not on regarding the eligibility of 15 or 10. But question is, what is the rational basis for differentiating between an arts graduate and a science graduate?
That is the valid.
And secondly, my lord, these high school teachers, therefore them the qualifying service is 10 years.
Both are on different tangent. Different tangent, because the graduate teacher of already or already serving in high schools.
Yes.
That is in place since 2018. Science graduate teachers are brought in with from amalgamated school with 15 years. And you are also like science graduate teacher from
Yes.
arts stream.
Arts.
So one is 15 years should be equally applied, irrespective of the.
No, we say, my lord, the substitution of proviso itself is bad. It is bereft of any rationale. Now, what is the objective, my lord? Kindly let state explain that the basis of classification is
But
to
that can be only in
final hearing.
finally.
No, my lord, some protection has to be given. If tomorrow selections are made, then our repetition will become infructuous, my lord. At least
But
14 posts, 14 petitioners before lordship, my lord. They should not fill up 14 posts.
Where is the advertisement?
Yes, and 97, my lord. My lord, when we filed the writ petition, it was at the stage of a communication from director to the inspector of schools. But subsequently, my lord, advertisement have also been issued. Huh?
Where is the advertisement?
Page 97 is a letter by director,
Letter.
my lord,
With public advertisement?
regarding filling up of vacant post of principal and advertisement we have not brought on record.
Any number or post? Any number in the advertisement? Any advertisement?
Hmm.
Once. 1.5 years down the line,
Ah. But when is the substitution? It is
No, my
21st.
lord, if your lordship would kindly come to serial number 1, number of vacant post of principal and headmaster of provincialized up to 31/12/23 in separate sheet under your jury following format. So they are having the numbers, my lord.
it's science graduate, so it's like good course. When we had raised this claim that we are also graduate teachers, we were enrolled as the graduate degree and now that the emergencies are leading us out to be. And also, yeah, justice was, and therefore, the consideration department subsequently. We need science graduate teachers of the. Also like Indian schools. Required this higher civil. There was only a batch of assistant, so science graduate teachers who had taken it. To teach those classes. Amalgamation since they become a part of the high school, even with the graduate, they will not include. Anybody with a graduation would be.
Without knowing the numbers, it will be difficult to.
My lord, we'll try to have the numbers. Let the matter
Yes,
come
if it is
tomorrow, my lord.
100, 150, if it is only 20, 30, 25, it will be very
Let it
difficult.
come tomorrow, my lord. I'll try to have the numbers.
Then if it is say run into 100,
And
we
my
can,
learned friend can also have the numbers, my lord.
you get the instruction how many
Numbers.
numbers at least, because petitions are 14 and we have to see that balance.
My lord, if we go by that order of this honorable court, my lord, yes, it's a fact, there was a litigation, there was a direction. Now it is something like this, my lord. Supposing in a cause, select list, person at number 10, 11 are appointed, the above are not appointed. Supposing serial number 7 comes and court issues a direction that why have you bypassed him, he is also eligible to be considered. Does it mean, my lord, by disregarding 1, 2, 6, 7 will be appointed? So naturally, my lord, that order of this court has to be construed in a manner which is consistent with Article 14 and 16. When you pick up the graduate teachers, what is the rationale? If you can, you may have a very good rationale if it is to the satisfaction of the court. If not,
Time, okay. And what is the time of likely completion of the process?
tomorrow.
Day after tomorrow? Again, should we see?
My lord, if it is not going to complete tomorrow, well, day after tomorrow, I will not be there.
Stood by Mr.
Maybe in the second half, my lord.
Land Council Board of Petitioners and Mr. R. Madinda. Land Standing Council, School Education Department, Postal, in order to place further instructions. Land Council Board of Petitioners has shortlisting of the case tomorrow, list the case according to tomorrow.
Tomorrow. Deep breath.
Second half, we have got it.
Yes. 2:45, I think
Yes, sir.
we are going to write.
Let it come in the month of July, my lord.
Okay.
23rd July.
23rd. Okay, 23rd. Okay. Duke 17 of 22 Duke number of 23rd July. To N. Ahmed Agopal Hilma, criminal appeal to 94 of 2016. Aru. Mr. Ahmed, you were in 3, right? Item number?
18 and 19, my lord.
Okay, N. Ahmed, Land Council for the appellants in 18 and 19. SCB was
17, my lord.
17, Land Council for appellants. And this is item 20, Kotoki. P. Kotoki. Land Council for the appellant in 20, and Mr. R. Kosik, Land Additional Public Prosecutor to respond number 1 state of now are present as sought for by the Land Council for the parties. List the appeals. These are the cases on 23rd July.
Also with a little liberty, your lordship. Item number 24, your lordship. There's an IA for continuation of delay, lordship. Lordship, inadvertently, some mistake has crept into the IA, lordship. I may be permitted to withdraw the IA with liberty, your lordship. Okay, to file a claim.
Item 24,
Lordship.
Mr. N. Gautam, Land Council for the applicant has submitted that some inadvertent errors. You are for a respondent. I have kept in the interlocutory application seeking condonation of delay. First of, he has sought liberty to withdraw the application. Okay, further liberty to file
Fresh one.
the application afresh. Mr. A. Parikh, you are for okay, Learned Council for the you are for Mozumdar with Mozumdar or you are standing counsel? Oh. Okay, Mr. Parikh, Learned Council for the opposite party, number 1 and 2, who is in attendance, has not objected to separate. So in view of the above submission made by Mr. Gautam, Learned Council for the applicants, the application is dismissed on withdrawal, with the liberty to as prefer. Both. The liberty.
Timing with the item 2.
Yes. Okay, material point is whether you have got the information or not. Polling area. What does it mean by DFN? DFN means foreign national. Okay. Soraikola Kokrajhar.
Yes, your lordship. Your lordship, I may be allowed to meet my daughter and your lordship, I may be allowed to take signatures in Wakalatnama, your lordship, to pursue the legal rebates, your lordship. Until then, your lordship, he may not be deported, your lordship.
What is the similar orders passed by the Korean bench? Okay. Same order. Yes. And Wakalatnama also.
Yes, sir.
Regarding quotation. That observation would be. Your lordship, because if your lordship, if I pursue the matter and thereafter if he is deported, the matter may become truthful. That part is there. You know, other matters.
We'll go consistently. Heard Mr. I. Hussain. Learned counsel for the petitioner, Mr. D.K. Sharma, and additional senior government of Assam for the responding 225. Postal. The reasons for preparing the petition have been mentioned, in brief, in our previous order dated 18/6/2020. And therefore, the same are not repeated hearing. First of all, it transfers that the petitioner's daughter, Afia Begum, is allegedly picked up from her matrimonial home at Kulagat on 25/5/2025 by police personnel from Komargaon Police Station, along with police officials from border branch. And since then, the whereabouts of Afia Begum is not known to the petitioner. Post of Para. On the previous date of listing, this court had directed the land counsel for the official respondents to apprise this court whereabouts of the petitioner's daughter, Afia Begum. Post of Para. Mr. Sharma, additional senior government advocate. On the basis of instructions received by him, a wide office letter number so and so, dated 19/6/2025, from the office of the senior superintendent of police, Kulagat, Assam. Has submitted that Afia Begum is presently lodged in the holding area, 7th Assam Police Battalion, Soraikula, Kokrajhar. Also. On such paradigm, is inclined to grant petitioner, namely Salimuddin, along with him, maximum 2 other persons, vegetation right to the detained person, namely Afia Begum, at the holding center under 7th Assam Police Battalion, Soraikula Kokrajhar, Para 6. Kalau nama likha আছে, huh? 7 to likhib. The visitation right has been allowed or not, huh? 7 to likhib. 8 to fine. Still normal explain. 8 to likhib, 8 to 9. 10, 11. Yes, when this can be listed.
That has been against pandemic because of condition.
When the Okalama signed, right? The lordship placed the case on 14/7. Immediately on the reopening. The instructions placed by Mr. Sormal and addition senior government advocate. Instruction are kept with the case record by marking it as document X. You need copy? What should furnish me copy? Only the order. I think only the order. It is there. First two pages. First two page you have got.
Got it. Right.
There were 15 orders.
Hmm.
Well, this is a IA minor in a criminal appeal minor, which is registered number under section 350 minor. The accused appellant has been convicted on 24/5/2023 under section 302 IPC minor, simpliciter. Though the
302.
302 minor.
Okay.
Then I was sentenced, order was passed on 26/5/23 with a life imprisonment and fine of rupees 5,000. So 7 PWs were examined and 11 exhibits were examined. So at the very outset, my lord, I would like to point out, my lord, that originally the FIR was filed against 6 persons, my lord. I translated the FIR, my lord. More dear, sir. I've given the translated version, original must be in the police record, and I've given the copy of the vernacular. To the officer in charge of Nalbari Sadar PS subject FIR, informant this one Koroda Halat, wife of Borunala, her daughter has been killed. That is the allegation by the following accused person. One is Kamal Kumar, who is the accused appellant. Rajiv Kumar not sent up. Jyotish Das, who was sent up but was acquitted by the same judgment, same evidence. Then Sumi Kumar is not sent up. Mother of accused number one not sent up for trial. Niroda Das, wife of Jyotish Das, not sent up for trial. So the facts goes like this, my lord. The basic case, the core case of the prosecution was that I would like to humbly inform you that about 2.5 years ago, the above name accused number one eloped my daughter Julie Halat in the pretext of a love affair, and they started living together. We, the family members, advised the couple of getting their marriage registered. However, the accused number one refused to comply and solemnized their marriage by traditional ritual. As my daughter was unable to conceive a child, the above named accused person subjected my daughter to physical and mental torture. Accused number one, besides physically assaulting my daughter, also threatened her with dire consequences. Today, that is on 27/3/2017 at around 12:30 p.m., the above named accused person in a conspiracy manner assaulted my daughter Julie Halat in the village field and thereafter dragged her home and put her in the bed. We got to know of the incident from the neighbors, but the neighbors who were examined has never stated all these things. Therefore, we humbly pray to investigate the matter. I put my thumb impression after the above information was written as per my saying. So this is the basic fact that as per FIR, my lord, she has come to know it from the neighbor, and she has come to know that the deceased was assaulted in the field and thereafter she was dragged to home and kept in the bed. Now, my lord, your lordship, say in this case, the doctor who has been examined as PW6. Page 24 and 25, your lordship will see. The doctor, my lord, could not opine also as to whether it is a homicidal death case or a natural death. Yeah, I should. The postmortem report is also exhibited, my lord.
All right. Special expert was examined.
Yes, my lord, the PM doctor was examined, my lord, and he has exhibited the document. His narration is given at page 24 of the IA, my lord, judgment. Roman 6.
Page 20.
4.
Twenty-four of the judgment.
24 of the judgment, my lord. Inner page 13.
Page 30.
Your lordship will find it in the IA, my lord. And in the appeal, the page is 42.
Judgment in our page 13.
13, my lord. Roman 6, my lord. At the bottom, my lord.
You want to say PW 6?
Yes. PW 6, Dr. Khonendra Mohan showed the
FSL was not examined, expired.
FSL was never examined during investigation also, my lord.
Okay.
Only Viscera was sent. He could not give the opinion. I'll read your lordship, it will clear. I have got a certificate
No,
copy.
we have read already. PW 6 we have read. PW 6 we have read. The main testimony we have read.
Yes, yes, the testimony is also there, my lord. So only one aberration was found, which is not sufficient in the ordinary course to
Yes.
cause the date also. Viscera report came subsequently where no poison was also found. So the doctor's postmortem, if your lordship wants to have a look, my lord, I have got a copy, my lord, I can share it. So there the opinion says the viscera and relevant paper document are properly sealed, packed and handed over to the escorting police to take to the Directorate of Forensic Science Laboratory for chemical analysis of viscera. It contains the stomach which solution such and such, then contains sample of preservative that is saturated solution of common salt. Opinion regarding cause of the death is kept pending till receipt of the chemical examination report from the Director of Forensic Science Laboratory. The injury is antemortem and caused by blunt weapon impact, which can be caused by any fall also.
Yes, madam. Three witness turned hostile. Informant post occurrence. PW5 post occurrence. And doctor turned the case upside down. What to do? Right. Right, chappal, and then after she fell down, then she walked. Then a branch of tree. But branch of tree is not consistent with the abrasion. Branch of tree would have a rough kind of thing, not by 10 centimeter into 1 centimeter. It will be broader. And not sufficient. He said, no, not sufficient. Plus, he further said, PW
6, Dr.
6. He further said, I did not find any other injury on the dead body
Apart from that,
apart from the abrasion. And informant saw cut marks.
Mr. The inquest.
Whether there is any provision, whether autopsy doctor can be declared hostile.
No.
Since how long he is in custody?
But since judgment, earlier too, he was there, but after judgment, 2 years, 1 day, man.
Hmm?
1 month, sorry.
2 years, 1 month.
month.
Yes, Madam Ras. Fair chances. The situation should arise that pointing unerringly towards him, a reasonable inference is required, but autopsy doctor is demolishing everything. Heard Mr. Jade Kamar, Senior Counsel, listed by Mr. P. Dev Chaudhary, Learned Counsel for the applicant, appellant. And Ms. N. Das, Learned additional public prosecutor for the opposite party, just respondent number 1, respondent state of Assam. Post of the present application under section 389 2 Code of Criminal Procedure 1973 within bracket presently comma 430 within bracket 2 Bharatiya Nagarik Surakha Nita 2023 bracket 4 is preferred by the applicant appellant seeking suspension of execution of the sentence passed against him and for his release on bail. Post of para. The applicant as the appellant has preferred the accompanying criminal appeal, comma, criminal appeal number 350 of 2022 against a judgment dated 24/5/2023 and an order on sentence dated 26/5/2023 passed by the Court of Learned Sessions Judge Nalbari, trial court for short, in Sessions case number 66 of 2019. Postum. By the judgment and the order on sentence, comma, the appellant has been convicted for the offense under section 302 for the offense of under section, offense of murder under section 3,
Charge was under 300-34, but convicted 302.
comma, Indian Penal Code. And he has been sentenced to under undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, in default of payment of fine, to undergo rigorous imprisonment for further 6 months. Post para, it is stated that the applicant appellant is serving the sentence since the date of the since the date of the judgment of the learned trial court. Judgment of the trial court. Stop. Para. Initially, the first information report was lodged on 27/3/2017 by the informant, PW1 against naming 6 persons as accused for the suspicious death of his daughter, Yuri Haloy, with whom the appellant stated to have solemnized the marriage 2.5 years prior to the incident. As per the FIR, the accused persons, named in the FIR, assaulted the victim at around 12:30 p.m. on 27/3/2017. And thereafter, dragging the victim to her matrimonial house, kept her in the bed post. The IO, after completing investigation, in connection with Nalbari Police Station, case number 201/2017, registered under section 302 IPC, read with section 34 IPC, on the basis of the FIR, said FIR, submitted a charge sheet against 2 persons, namely, 1, Kamal Kumar within bracket, the applicant appellant, and 2, Jutesh Das, finding a privacy case against them for committing the offense under section 302 IPC, read which section 34 IPC. In the course of the trial, the prosecution side examined 7 number of witnesses, 7 number of prosecution witnesses, and exhibited 11 number of documentary evidence. After by the judgment, an order the trial court, while holding the appellant guilty for the offense of murder, acquitted the other charge-sheeted accused person, namely Jutesh Das, from the charges. Custom. Para. During, out of the 7 prosecution witnesses, including the autopsy doctor who testified as PW 6, 3 of the prosecution witnesses, PW 2, PW 3, and PW 2, I think. 2. Turn hostile. Also. Though their previous statements were recorded under section 164 CRPC. First of the remaining witnesses, PW 1 as informant. PW 4 and PW 5. Were witnesses who arrived at the place of occurrence, that is the house of the applicant and the deceased, after the incident which resulted into the death of the appellant's wife. Their testimony is to the effect that the disease was found lying on bed inside the room of the house. The disease was found under suspicious circumstances on 27/3/2017. The postmortem examination of the dead body of the deceased was performed at SKM Civil Hospital, Nalbari, at about 2:50 p.m. on 28/3/2017 by PW 6, who was serving as the medical and health officer -1 at SKM Civil Hospital, Nalbari, on that day. After conducting autopsy on the dead body, the autopsy Dr. PW 6 found an abrasion on the person of the deceased of size 10 cm into 1 cm present over lower border of mandible. PW 6 had opined that the abrasion injury found on the dead body of the deceased could be caused due to dashing on rough sentence. The said injury alone would not be sufficient to cause death. He had further testified that he did not find any other injury on the dead body of the deceased. PW 6 forwarded the viscera for chemical, did not also find any ligature mark, did not also detect any ligature mark on the person of the deceased. PW 6 forwarded the viscera for chemical analysis, and on the basis of the viscera report he had received, he stated that no poison was found in the vessel. He further opined that he further stated that he could not opine whether the death was homicidal or otherwise. And having regard to the above facts are noticed upon perusal of the evidence stock materials available in the case record of Sessions case now showing original, which we have perused for reaching a privacy view for consideration of the present application. First of all, having a regard to the above evidence of materials on record, we are of the privacy view that the applicant has made out a case for suspension of execution of the sentence passed against him and for his release on bail. 25,000 was mentioned. Emil appeal. Oh. Jet Kamal, Senior Counsel, still President. So, what happened? Ms. Endas, the additional public prosecutor, but the respondent state the case records of section case number so and so have been received. Ready to prepare the paper book, lays the case after 4 weeks for a report as regards the readiness of the paper.
With your losses, you permission. My item was 21. So may I take it then?
After vacation, obviously.
Yes, after vacation.
21. Okay. TK Mishra for the petition. And Ms. MD Bora, the standing counsel, Transport Department. For the
So I am
state
entering in
response.
item number 22.
Mr.
PJ Bora.
PJ Bora, item 22, petition. As sought for by the land council for the parties, list the case needed immediately after the answering some application. Let the changes come, then court will. In the meantime, everything will be changed. Then immediately after that, Mr. Prasad. Mr. Prasad,
My lord, Mr. Prasad is not well.
not well. Okay, then we defer it after vacation. Your name, please.
L. Das.
Elders, learned counsel for the learned counsel, appearing on behalf of Mr. B. Prasad. Learned counsel for the learned amicus query. Amicus? Amicus? Amicus. For the appellant has submitted that Mr. Prasad is indisposed and has thus sought for listing of the appeal on another date. Post of Ms. S.H. Boral and additional public proceeding of the respondent state is in attendance. Also, in view of the ground cited, let this appeal be listed again on Monday, 15 July.